All right, let's step into the courtroom for a moment. We're not just looking at a topic today, we are hearing a case. And the question before the court is this: should animals, by law, be recognized as sentient beings in Singapore? The evidence is powerful, the stakes are incredibly high, and the verdict could change everything. So let's start with the prosecution's first piece of evidence. It's just a number: 6.
So what does that 6 mean? That's the average number of animals that are victims of cruelty or die from it in Singapore every single day. This isn't just some abstract statistic, it's the absolute heart of the matter. It's the tragic reality that sets the stage for the entire legal question we're about to unpack. So that brings us to Act 1 of our proceeding, a case of cruelty. To understand the problem, we first have to understand the legal world where these tragedies are taking place.
And at the center of that world is the core legal argument, something we're going to call the law's critical gap. To really get it, we need to look at the main law that's currently on the books. Here it is, the Animals and Birds Act of 1965. This is pretty much the foundation of animal protection in Singapore. And, it prohibits causing unnecessary pain or suffering. But take a closer look. See what's not there? There's no mention, no definition, nothing that explicitly says an animal is a sentient being that can actually feel things. And that right there, that's the whole problem. This absence is what legal experts call a critical lacuna, which is really just a fancy way of saying there's a giant gaping hole in the law. Without that basic recognition of sentience, everything else, from how cases are prosecuted to how rules are made, is built on pretty shaky ground. This whole issue was really thrown into the spotlight back in 2016 with a landmark case involving a dog named Hugo. He was a Shetland sheepdog, and he was found locked in a cage so small he could barely even move. This case basically forced the courts to figure out what suffering really means.
And what the court said in Hugo's case, wow, it was a huge deal. The ruling stated that an animal's welfare doesn't just depend on whether it's physically healthy. For the very first time, a court made it clear that suffering isn't just about physical harm. An animal could be perfectly healthy on the outside, but still be going through absolute psychological torture. The court was, in a way, recognizing sentience without actually saying the word.
But here's the thing. Just implicitly recognizing it doesn't cut it. That critical lacuna we talked about has very real consequences. Because there's no explicit definition, judges are kind of left to interpret things on their own. Trying to prove psychological harm becomes incredibly difficult, which leads to inconsistent enforcement. And so regulators tend to just focus on the easy-to-measure stuff, like the size of a cage, instead of an animal's actual mental and emotional well-being. Now, like in any good legal drama, you can't look at a case in a bubble. So it's time to call some expert witnesses. Let's hear some testimony from abroad and see how other major legal systems have already dealt with this exact issue. So let's start at the very top. We're talking constitutional law. The entire European Union wrote right into its founding treaty that animals are sentient beings. Germany actually changed its constitution to protect animals right alongside the natural foundations of life. This isn't just some small rule change, it's a statement of core values. Then you have other countries that have passed entire laws just for this. The UK, for example, now has a dedicated animal sentience committee to make sure government policies are considering animal welfare. And New Zealand, way back in 2015, was the first country in the world to just come out and say it, amending its law to state, loud and clear, that animals are sentient. But this next one might be the biggest shift of all. Some countries have changed the very legal definition of what an animal is. France used to classify animals as movable property, like a chair. Now the law says they are living beings gifted with sentience. And Spain has gone even further, recognizing them as sentient beings and, in some legal situations, even as family members. The international precedent here it's overwhelming. Okay, so we've heard the international testimony. Now it's time for the closing argument. We're turning our focus back to Singapore, where you can feel this incredible momentum for change building up. And look, this isn't happening in a vacuum. It's like 4 powerful forces are all coming together at once. You've got the scientific consensus, which is pretty much undeniable at this point. You've got the courts, like in Hugo's case, that are slowly starting to get it. You have major advocacy groups like the SPCA and ACRES pushing hard with a clear plan. And, this is the big one, the government itself has committed to reviewing the law. And that brings us right up to today. You can almost hear the clock ticking on this. Back in 2025, the advocacy and the government's promise lined up.
Now, by the end of 2026, the public is scheduled to get its say. So this isn't some debate about the distant future. It's happening right now. This is the window of opportunity.
So what's the actual fix being proposed? Well, it's actually really simple and direct. This is the amendment that advocates want to see. It's a clear, science-based definition that would be added directly to the Animals and Birds Act. It's not about giving animals human rights. It's simply about the law finally catching up with the biological reality of what they are, beings that can feel. So here we are, the final phase of the trial, Singapore's final verdict. All the arguments have been presented, and now the choice rests with the nation.
Let's be really clear about what's on the line. This is a chance to finally close that gap between what science knows to be true and what an old law says. It's a chance to make animal cruelty cases more consistent and predictable. It's an opportunity for the law to actually reflect society's modern values. And frankly, it's a chance for Singapore to set a standard for compassionate governance for the whole region. So, there you have it. The evidence is in. The testimony has been heard. That critical gap in the law has been exposed, and a clear solution has been proposed. The question is no longer if animals are sentient, but whether the law will finally acknowledge it. How will Singapore roll? Well, the jury is still out.